Sure, that'd be good.
That case is Chad Mott, 24 CF 1643. I believe the document's been signed by all parties for a misdemeanor in that case. May I approach?
Yes, sir, thank you. Thank you, sir.
Did I sign that, Jason?
Rachel, who's next?
Jeremy Ross.
Thank you.
Mr. Cox.
Oh, so that's a possibility.
Yeah, I'll probably dismiss it by Thursday. I can't dismiss it right now.
Okay.
Yeah.
Mr. Ross. Judge, this is Mr. Jeremy Ross, 24 CF 1756. It's a violation of probation. Mr. Snell. This is Mr. Jeremy Ross. It's a violation of probation. The new law was a loitering charge, hasn't been filed on yet. This was the one at the church that's open 24/7. That's going to get dropped.
Hello, Mr. Ross.
You can loiter in the
Hello,
crowd.
how you doing, Judge Brown?
Good, how are you?
I'm doing great.
Good.
Sorry about earlier. About the procedure.
I forget.
Yes,
Yes,
sir.
Judge, the state is kind of looking, the new law was a loitering case that haven't filed on yet. My argument was it was a church open 24/7, so we're going to see if we can dismiss this today, Mr. Ross.
Okay.
Just want to listen to the state attorney. Oh, you're good. You're doing good. So, of course, if they dismiss the violation, you'll be released on my charge.
Okay.
If not, well, we'll see here.
It'll take a minute, Judge, so
Do you want to pass Mr. Ross and bring him back?
Thursday.
Bring him back Thursday?
Yes, sir.
Okay, so is the only thing that's holding Mr. Ross in jail in this case?
No,
It's a new law violation.
and the new law violation, Judge.
Okay. Mr. Ross, I'll see you on Thursday, okay?
Okay.
They're going to bring
Thank
it
you,
back
sir.
here Thursday.
Okay. Cool. Are you gonna be here?
Absolutely. Follow that deputy, but I will be here.
And Mr. Stewart's case, whenever you can get to that?
Okay, Johnny Santiago Rodriguez.
Thank you.
You're crazy. It's a crazy one. Crazy.
Good afternoon, Mr. Rodriguez.
But we have to go set this up. I don't think you're ready to dismiss it today. Okay. Oh, good afternoon. Judge, this is Mr. Santiago Rodriguez in 24 CF 1478. We had some correspondence with alleged victims sent over to the state. They're not ready, or they're not dismissing the charges today, but I already have the alleged victims subpoenaed, scheduled for December for depositions.
Good.
So ultimately, I'm requesting this case to be continued to the 13th of January, but we have those important depositions already set.
Okay. Mr. Santiago Rodriguez, do you understand what Mr. Koch is doing in your case? Do you understand about the depositions?
No, sir.
Okay. Mr. Koch, so you are deposing the alleged victims?
Correct, Judge, and I have received emails, non-sworn emails from the alleged victims. I can't confirm it. I have no.
So you subpoenaed them?
So I subpoenaed the alleged victims at my office for the deposition so we
Good.
could get to the bottom of it.
Okay. So,
Didn't my sister send you an email?
Correct, and I always forward it to the state, and I always ask them, I say, hey, it looks like the victims want to drop the charges. Of course, I can't drop charges.
right.
If the state's not going to drop it, then I continue. I didn't wait for the send out subpoenas for my depositions, already scheduled. So
Gotcha.
that's the next step.
Okay. So the court will see you no later than January 13th. If the state decides to drop the charges before that, then Mr. Koch can set it for a hearing. Thank you.
Robert Shumake with Mr. Stewart.
Thank you. Hello, Mr. Stewart.
Good afternoon, Your Honor. May it please the Court, Your Honor, Brad Stewart, on behalf of Robert Shumake, Judge 24 CF 2561, we're before the Court with our continued motion to reduce bond on behalf of Mr. Shumake. Judge, at our last hearing last week, the State and the Court requested additional time for medical records to be presented. We did forward those over to the State and the Court's judicial assistant. Has the Court had an opportunity to review those?
I did, yes, sir.
And just this afternoon, Judge, when I arrived at the courthouse, I did receive some additional materials. I provided that to the State Attorney's Office a moment ago. It essentially consists of the two most recent doctor's reports, I believe one in April, and then one as recent as October the 8th of this year, which both were pre-operation doctor's appointments. In the materials I provided to the State and the Court, it indicates that he has a December 31 office visit at Shands in Gainesville, Judge, beginning at 8:30. The other information I provided to the Court, of course, on short notice, just generally went over the level of injuries, the level of overall impairment that Mr. Shumake's injuries brought to the table, if you will. If I'm not mistaken, I believe there was somewhere around 80% loss of function with regards to use of his right arm. The goal is to get back to 15 to 25%, if I'm not mistaken. And that is the genesis of his surgeries, Your Honor. I also want to bring to the Court's attention that he is in enormous amount of pain with regards to the injuries, Judge, and there's a significant amount of medication that he is on with regards to pain management, as well as mental health medications. And of course, Judge, as far as bond factors go, I get the State's argument. I certainly respect and understand protection of the community. I would point out that the date of this event was June 18, 2023, and Mr. Shumake was not arrested until 16 months later, November 4th, 2024. We have no instances of any kind of arrest in this or any other state on behalf of Mr. Shumake. So I would submit to the Court that Mr. Shumake is certainly a viable candidate for a release on bond. Judge, again, we would renew that request, and his family is requesting a signature bond, Judge, and his significant other has indicated that he could do $5,000 cash professional with pretrial services. Of course, Judge, no objection to any random urine analysis. And his family is here, Judge. They are in the front row.
Good, excellent. Thank you. To the State.
We did receive the paperwork that Mr. Stewart advised the Court that would the Court like to review it as well.
I've got these copies.
This is different.
Yeah, this is the additional materials that I just went over, the two pre-ops.
Because I was going to say, I didn't see what you were talking about in this homework.
Right, these are the two pre-ops. I believe it was, yes, it was April 24th, 2024, and October 8th, 2024, Your Honor.
Please, yes, sir. Thank you, sir. Okay, to the State.
The charges are very serious. At the same time, with the medical issue, I would leave it to the discretion of the Court, whether after reviewing that material, whether or not. I feel like that this, with the nature of the charge and it having a minimum mandatory prison sentence attached to it, the bond should be more than a signature bond. But that's the State's position.
Okay. If you'll give me a moment, Mr. Stewart, I want to pull up the arrest report.
Yes, sir.
First, I looked at the first appearance information, which shows 1 prior failure to appear, 4 violent felonies, 7 violent misdemeanors.
Judge, I apologize, I'm unaware of violent felonies. I know there was 2 felony batteries in 2017. I did see that, and I would be remiss if I didn't say that there is decisional law out there that says felony battery is not necessarily considered a crime of violence. So the other violent felonies I'm unaware of, Your Honor.
Okay. And I thought that looked familiar. I did review that previously, both the first appearance paperwork and the warrant, and highlighted some matters in that. Has an information been filed?
Not that I'm aware of, Judge.
Okay. Okay. Now I'm looking at the paperwork that Mr. Stewart, or the state, just gave me. When I was looking at what you previously provided to the court, stated in the discharge summary, I'm trying to find a date. In the discharge summary, it states, failure to attend 3 scheduled therapy appointments. No, that's just what they're stating. They aren't saying that Mr. Shumake didn't attend those. That's just the guidelines, but that caught my attention. Good.
Judge, I think they discharge you if you skip through the warrant.
Right, and that's, I was looking, if Mr. Shumake was asking for the court to take credence and he needs help, and he didn't do it before he went in, then that would have made a difference. But I don't see anything that says you didn't attend physical therapy when you were supposed to. So if
Been
you,
going 2 to 3 times a week for quite a while, sir.
okay,
And to that extent, Judge, and I was just provided this tip 20 minutes ago, Judge, when I walked in, but I do have a schedule of his appointments, and it looks like there's no unexcused ones except for one in July, it seems.
so where does it state that Mr. Shumake needs surgery and when they're planning on doing that?
Your Honor, the surgery date, it looks like, is, I believe, on page 1 of the original materials provided to the court. It indicates future visits, December 31st, 2024, office visit, UF Health, plastic surgery study.
So what is the diagnosis and prognosis?
Judge, in this material, the material that I provided to you, I believe they indicated their goal is to get Mr. Shumake to 15 to 25% disability with regards to that arm.
And do that how? Physical therapy or surgery?
And a combination of two, and I believe Mr. Shumake can speak to this, if I can, Judge.
Okay, Mr. Shumake, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can put your hand down.
Okay, so basically, I spent about a month in the hospital after the accident. They did 8 or 9 surgeries. The last one was a major reconstructive surgery, all right, when they're not done. And they, it being in Gainesville and us living here, we were having to go back and just for him to check on it, this and that.
Yes, sir.
So he agreed to continue to do the reconstruction work on it as long as I did the therapy. And he suggested, twice a week. So that's why I went back in October and he looked at my hand, and that's when he set the date for the final pre-op visit of the 31st of December, at which point I'm supposed to go in, and then he's gonna, as long as he thinks it's, still healing, he's gonna fuse my wrist to where I don't have any movement in my fingers unless my wrist is kept straight. So he said he would fuse my wrist to where I could start trying to rehab the finger movement. And then also this flap from where they've cut out of my arm to put on top of my hand.
Yes, sir.
They're gonna stretch that and reconstruct that so it doesn't, I'm just in a lot of pain. And they're
Okay.
trying to do everything they can without cutting my hand off.
Did they say anything about delay or about degenerating, that if you don't keep up with the physical therapy, then
They told me
you're gonna
they
lose?
would not continue the work. And the first plastic surgeon that did all the reconstructing, he was,
Okay, Mr. Shumake, let me interrupt you.
sure.
You want these back, Mr. Stewart? Mr. Shumake, it just seems reasonable that the physical therapy and the surgery, if you don't have those relatively soon, that there may be more permanent damage than there already is. So the motion is granted. Your bond set at a $5,000 cash or professional. How many counts are there? Okay, $5,000 cash or professional. So once you pay that, you'll get out of jail today. The court does, and again, I don't have I think the state said you wanted pretrial services. And what would be the conditions for that? What does pretrial need to do?
Just a month, he would check in.
Okay. And you live in Gainesville?
No, sir, I live in Destin.
Okay, but you're going to be going to Gainesville?
Yes, sir.
Okay. I do appoint pretrial services. You'll need to periodically check in with them. I don't think there are any other terms on the pretrial other than you can't commit any new law violations between now and when your case is resolved, and stay in touch with pretrial, okay? And then, Mr. Stewart, and your case will come back before the court on January 13th. If you're in surgery, if there's something that you can't be here physically, stay in touch with Mr. Stewart and he'll let the court know. Otherwise, you need to be here January 13th at 9 o'clock.
Okay, so when my people post the bond, how long will I have to sit in the jail?
They'll let you out
We'll take care of it.
immediately,
Okay,
okay?
Judge, one housekeeping matter, the court has no objection to him traveling for the medical needs. I just want to get out ahead of that.
I do not.
That's
Not a bit, no, sir. Okay. And thanks for your family being here. It means a lot to the court. Thank you.
And Madam Clerk, is that captured everything that would be sufficient?
Yes, I was going to ask for clarification periodic check-in.
Yes, ma'am. That'd be good. Thank you.
And Judge, the clerk minutes will be sufficient for purposes of today, or would you prefer an order?
The minutes are certainly good with me, but if you want to get me an order too, I'll sign them tonight or this afternoon.
Very good.
Okay?
Very good.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Shumake.
Yes, sir, thank you.
Your Honor, that's all I have, may I be excused?
Yes, sir. Thanks, Mr. Stewart.
Thank you, Your Honor.
Alex, lawyers next.
Judge, may I just a brief moment?
Certainly.
Judge, Mr. Sawyer, we're here in 23 CF 2432, 24 CF 410, 24 CF 617. It was set for plea or continuance. There's still an outstanding FOE report in the 617 case, but speaking with Mr. Snell, he's going to provide me with a score sheet, and we have a counter offer on the table if we can bring back the client on Thursday.
Okay. Mr. Sawyer, I'll see you on Thursday.
Yes, sir.
Thank you, sir. Thank you, ma'am. Hello, Mr. Smith.
Judge, this is Mr. Smith in 24 CF 111, 24 CF 1640. A similar situation. The state's going to provide us with a score sheet and an offer, and we have some counter offers. So we can bring back my client in person on Thursday.
Okay. Mr. Smith, I'll see you on Thursday.
All right.
Benjamin Smith.
You like it for anytime sooner or anything?
Okay, gotcha. Yes, sir.
Thank you, sir.
Benjamin Steen.
Thank you.
Mr. Steen, come on.
Judge, this is Mr. Steen in 23 CF 2253. This was a case where the a witness that I label as an alleged victim failed to show twice for depositions. I was hoping to get this dismissed today, fortunately not. Ultimately, I'm asking for the continuance to 1/13, but I predict a show cause hearing very soon.
Okay.
So ultimately to the 1/13 date, but that's my next step.
Okay, so Mr. Steen, here's what I've heard, is that your underlying case is continued until January 13th, but Mr. Koch intends to file a motion to compel the alleged victim why they shouldn't be held in contempt, and then he'll set that for a hearing. The alleged victim will be put on notice of that hearing. We'll have a hearing in the next few weeks, I would think, and then the court will rule on that motion to compel or a motion for contempt against them. You shouldn't be sitting in jail if people aren't showing up when they're supposed to. Okay? So I'll see you then.
Thank you.
Thank you.
Yes, sir.
John Sumerall, isn't it?
Hello, Mr. Sumerall. Good afternoon.
I don't know if he scores or not, but this is a Thursday. Is that potential?
Yes,
Yes, Judge. It's John Sumerall, 24 CF 1031. Speaking with the state attorney, they're going to get us the score sheet. If we could put them on the Thursday docket, and I'll leave it like that, but we're going to bring you back in person on Thursday.
Mr. Sumerall, I'll see you on Thursday. Thank you.
Alison Snipes is
Thank you. Well, Ms. Snipes.
Judge, may I have
Yes,
a
sir.
brief moment? Speaker of the state this morning, they agreed to want to set guidelines of 18.45 months.
That is starting.
You mean like credit time? Anytime you mention you get groceries, credit for all time.
So that all their, like you said before, that the starting.
Well, I don't want to mislead you anyway, I'll make it easier. 15.45 months DOC, the judge will say you get credit. If you want to accept it, you have to jail the whole U.S. term. But what exactly credit time you want? Like what you were saying. But you do get credit for the time you been in jail. If it's, I don't want to like misstate anything, I mean, on these charges, when you're arrested on these charges, you get credit. So, thanks, Judge.
Yes, sir.
This is Ms. Alison Snipes, 23 CF 1824, 24 CF 1346. We are set for plea or trial. Speaking with the state attorney's office, they've agreed to a guideline sentence of 15.45 months. I was briefly speaking with my client about, we were in front of Judge Gonter back on September 25th. Unfortunately, that offer expired on that day, so just want to make it clear we're here for 15.45 months DOC, course credit for time served, court costs, and ultimately revoke and terminate probation. So Ms. Snipes, we're geared up, ready. Like I said, this is plea or
Right.
trial.
So, Ms. Snipes, you can either accept that offer, we can go to trial in a couple weeks. If you say, I don't know if I want to accept that offer or not today, we can ask the state if they'll hold it open, that offer open until Thursday. I'm going to see you on Thursday if we're heading toward trial. I can't make the state hold something open, even if they say they're going to leave it open and they decide to withdraw it. I can't make them re-offer it. So just be mindful of that. So you've got to tell me, do you want to accept the state's offer or you want to go to trial?
If I go to trial, does it go back to when I got the burglary charge?
When you got the burglary charge?
Like when I got charged with burglary, does it open all of that back up?
You mean, is the state going to amend the information to add additional charges?
I believe,
No.
she's
Please.
asking about a violation of probation. Not,
No, I'm talking about like when I got the charge, the burglary charge in the first place. Does it open that up?
okay, now, no, that he can explain that to you, but no, it wouldn't reopen.
So, Mr. Koch, what is the, and Ms. Snipes, I don't say this to try to get you to agree to something. When I was practicing law, when a client came in, I wanted to make sure that they understood the downside, the biggest downside, because I knew the upside would take care of itself. So, Mr. Koch, what's the maximum that Ms. Snipes could be sentenced to?
Certainly, Judge. If, speaking with the state, if we choose trial, they're going to move forward with the VOP first. And it's 3 counts on that VOP: burglary, unoccupied conveyance, maximum 5 years prison. Count 2, crime against public servant, 5-year maximum prison. Count 3 is resisting officer without violence, so that's a 1-year max. So
11 years?
11 on the VOP, Judge, yes.
Okay.
And then the new law, if it needs to be tried after, of course, possession of controlled substance, 5 years.
Okay. So, Ms. Snipes, you could be sentenced up to a total of 16 years in prison. I have no idea what I'd sentence you to if the jury finds you guilty, so I'm not saying that to try to coerce you or tell you to do something. I just want you to know your downside. The state would seek the violation of probation first. Correct, Mr. Snell?
Yes, sir.
Okay. Ms. Snipes, so, Mr. Snell, will you leave the offer open through Thursday?
I would, yes, sir.
Okay. Ms. Snipes, do you want to wait until Thursday and come back? What would you like to do?
I just sign it.
Okay, you want to agree to
I
the
don't
plea?
want to do this anymore.
Okay, so you do want to enter the plea?
I feel like I'm forced to do it, but yes, I'm just saying. I
Okay,
do feel like I have no better choice.
I understand. And what I always say is, do you feel like it's in your best interest to do this? It doesn't mean do you like it, it's just do you feel like it's best?
I feel like I don't have a better choice, so yes.
Have you read the plea agreement?
This one?
Yes, ma'am.
No.
Okay. I want you to read that, okay?
Okay.
So I'll send you back with that, and then they'll bring you back in a little bit.
Okay.
But read through it.
All right.
Thank you, ma'am.
Christopher Whitney is next.
Thank you.
Whitney.
Do you have a full chance to read that through? Yes, sir. Do you have any? Sign it and date it. Judges, Mr. Christopher Whitney before the court in two case numbers, 24 CF 1783 and a felony violation of probation, which is 21 CF 848. We've reached an agreement that handles both of those case numbers.
Good afternoon. Mr. Whitney,
Yes, sir.
while we're waiting on that, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
The plea agreement contemplates a plea as charged in 24 CF 1783. The sentence in that case will be time served in the Okaloosa County Jail, $867 in court cost, $150 cost of defense. In 21 CF 848, that is a felony violation of probation, there will be an admission to the felony violation of probation. His probation will be reinstated to complete the original requirements. There would be an additional $100 BOP fee and an additional $100 cost of defense. We would ask that the monetary amounts that I just announced in the other case be paid through the period of probation. May I approach with the plea agreement?
Yes, sir. And the adjudication is what?
Judge, he was originally adjudicated in 21 CF 848. That would be an adjudication. And in 24 CF 1783, that's also an adjudication.
Okay, thank you. Mr. Whitney, so did you read the plea agreement?
Yes, sir, I did, sir.
Do you understand it?
Very well, sir. Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Very, sir.
Mr. Whitney, I do accept your plea. You're adjudicated guilty in both cases. You're sentenced to time served in 24 CF 1783 and 21 CF 848. You're adjudicated guilty. Your current supervision is reinstated with all the original terms and conditions. You'll need to pay a $100 cost of prosecution, total of $250 public defender's fee, and you'll need to pay the court costs in the new case. You'll need to pay those during your probation. Thank you, sir. Good luck to you.
Thank you, sir.
Yes, sir.
Randy Williamson.
Judge, hold on. One moment, please. Judge, the state is indicating that we neglected to put in a term in the plea agreement of reserve over the issue of restitution. May I explain that?
Yes, sir.
Judge, I just explained the request to Mr. Whitney. He has no problem with that being part of the plea terms that we just discussed.
Okay, but that would be on the new case, right?
Yes, Your Honor, that would be in 24 CF 17.
So if that was time served, how does that work?
Judge, we would reserve over the issue of restitution, and if the state petitions for any restitution, if the court orders it, then it can become part of 21 CF 848, which is the felony violation of probation.
So 90 days for the state to move for that or petition?
Yes, Your Honor.
And then if they do and the court awards restitution, then that restitution will be paid during the supervision in the 21 CF 848 case. Is that what I hear?
Correct.
Okay. Mr. Whitney, you okay with that?
Yes, sir.
Okay. You agree to that restitution, to the court awarding restitution?
Yes, sir.
Okay. Thank you, sir. That's part of the plea agreement.
Yes, sir. Thank you.
Mr. Whitney, ready? Randy Williams is next.
Judge, this is Mr. Randy Williams before the court.
Oh, Mr. Williams.
How are you, Mr. Ryan? Look good today.
Good. How are you? You
Been
too.
stressful for you.
Thank you, sir.
Judge, Mr. Williams has 24 CF 2057 and 24 CF 2508, which is on the arraignment docket for December 2nd. That is a new case. Procedurally, I would request a continuance until the January 13th court date for Mr. Williams and 24 CF 2057. I'd like to leave the other case on the already scheduled arraignment date. And the court will see Mr. Williams already on the 21st at 2:30 for a bond hearing related to both cases.
Okay. So I'll see you on Thursday regarding the bonds.
Okay.
And the new case,
Procedurally, 24 CF 2057 will be a continuance until January 13th.
okay, good. Yes, sir.
And in the new case, I don't want to.
Arraignment on December
I want to keep the
2nd.
arraignment for December 2nd.
So I'll see you on Thursday, and then I'll see you on December 2nd. Thank you.
Christopher Williamson is next.
Thank you.
Judge, this is Christopher Williamson. Mr. Williamson is before the court in two cases, 24 CF 2075 and 24 CF 2173. One of those we advanced off of the January court date to today to try to resolve it. We've been able to do so. This was plea or continue. It's not on the trial docket. That leaves us in a position that we must ask for the continuance of both of these case numbers until January 13th. But I've been speaking to the state, and our intention is to resolve this matter by the end of the year, hopefully sooner rather than later. There's not a bond motion that's currently filed, but I will be filing a bond motion that will be bringing Mr. Williamson back before Your Honor at the earliest available miscellaneous date.
Okay. Mr. Williamson, I'll see you no later than January 13th, but if Mr. McKinney files a motion, I'll see you at that hearing before then. Thank you.
Thank you, Judge.
Stephen Willis is next.
Thank you.
Judge, this is Mr. Stephen Willis before the court in two cases. Mr. Willis has 24 CF 1111. Have you had a full chance to review the plea agreement?
Pretty much.
Do you have any questions for me? And Judge, he's reviewed a plea agreement and the current offer from the state, and he would need to execute it at this time if he has no questions.
Just what they do.
to the state, if you want to try to email Mr. Stills, because his client is still on the queue or in the queue.
I don't really have his, I'll try to find it on the clerk's side. I don't have his email.
And Judge, the agreement for Mr. Willis.
Yes, sir.
agreed to enter a plea as charged in 24 CF 2111 and admit to the violation of probation in 24 CF 964. The agreement contemplates an adjudication of guilt, a concurrent 6-month Okaloosa County jail sentence that will revoke and terminate the probation in 24 CF 964. There's the $515 in court cost, a $100 VOP fee, and a total of $250 cost of defense. He was previously adjudicated in the other case. May I approach?
Yes, sir, thank you. Mr. Willis, if you'll raise your right hand. Your other right hand.
Oh, my bad.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can put your hand down.
Okay.
Mr. Willis, did you read the plea agreement?
I did.
Do you understand it?
Yes, I have.
Did you discuss it with your attorney?
Yes,
Did he answer all of your questions?
he certainly did.
Are you satisfied with his representation?
Most definitely, and so,
Good. Did you sign the plea agreement?
yes, I did.
Mr. Willis, I do accept your plea. You're adjudicated guilty. Your current supervision is revoked and terminated. You're sentenced to 6 months in the Okaloosa County Jail. That's to run concurrently, run at the same time, and that's with credit for all time served. You'll need to pay the court costs, total of $250 public defender's fee, and a $100 cost of prosecution. How long will you need to pay that after you get out of jail?
6 months
Okay.
to a year at the most.
Okay, how about I'll do a year, okay?
Okay, that's fine.
Sounds good. Thank you, sir. Good luck to you.
Thank you, sir.
And I just wanted to make clear on the record, outside this agreement and sentence, some of those terms are going to be D6'd against his license because they are DUI terms. So you need to talk to the DMV once you're released to see what it's going to take to get your license back.
Okay, I do. Thank you.
Thank you.
Amy Judicial is next.
Hello, Ms. Siska.
Judge, this is Zishka before the court. This is a new case in 24 CF 2025 and a total of 3 felony violations of probation which are tracking along. And Judge, procedurally, I'm going to be requesting a continuance until January 13th. I have already filed a motion for bond and a notice of hearing for Thursday at 2:30. So
Okay.
Your Honor, we'll see Ms. Diska back this Thursday for a bond hearing, and we're also going to try to resolve the matter. But procedurally, I would request a continuance until January 13th and ask for the felony violations of probation to track along with that.
Okay. So, Ms. Ziska, your case, all your cases are continued to January 13th, but I will see you Thursday on your motion hearing. Okay?
Yes, sir.
Thank you, ma'am.
We can recall Alison Snipes.
Judge, you got to recall Miss Alison Snipes. Just on the record, having read, or did you have enough time to read that plea form?
I mean, I skimmed over it because I don't know, does all of this apply to me?
Judge, I'm requesting that we set her on Thursday. I've already had a Nelson hearing, unfounded, but allegations of, forced pleas. If she needs more time, clearly she has questions. If we set her on Thursday, then I can answer those questions, probably.
Okay. Ms. Snipes, since the plea offer is time in prison, I don't see any downside to us continuing the hearing until Thursday. So I'll see you on Thursday. Read through all of that. Mr. Koch, when she asked, do these provisions apply, were those like sex offender things?
Yes,
Okay.
Judge.
Make sure you go through that with her.
Absolutely.
Ms. Snipes, Mr. Koch is concerned that, you said, I feel like I don't have a choice. Nobody's making you enter this. You've got to decide. And I say you roll your eyes. You go, nobody's making me enter it, but if I don't take it, I may get sentenced to 16 years in prison. That's what makes you do it, right?
Yes.
Okay. Just know that you don't have to accept it. You can go in front of the jury. The jury can decide if you're guilty or not. I'll decide what I think a reasonable sentence is. So you don't have to take it. I just want you to do what you think is in your best interest, knowing everything that we've told you and that you've heard from your attorney, okay? So we'll talk on Thursday. Okay? Thank you.
We're going to recall Eric O'Malley.
Thank you.
He's on Mr. Klein's portion of the Mr. McKinney's.
Okay, thank
And
you.
Judge, I'm standing in for Mr. Kleins, for Mr. O'Malley in 24 CF 1152. I believe the intention is to leave this scheduled for Thursday.
Okay,
That's correct, Your Honor.
so set for trial, correct?
That's correct.
Yes, Judge.
And I believe Mr. Kleins is going to be filing a bond motion on Thursday, to be heard Thursday. I think it's the intention of the state and the anticipation of the state that the case will be resolved in totality on Thursday, but if it's not, then we'll have a bond hearing at that time, Your Honor.
Okay, so I'm going to set it for a status even though he hadn't filed the bond motion yet.
Correct. I know that he fully intends on filing that. He let me know before he ever left court that that was going to be the case.
Or actually, it's jury review anyway, right?
Yeah.
Okay, so Mr. O'Malley, I'll see you on Thursday, okay?
I'm so ready to just go home. The dude lives in Kansas now. I don't even think I'm not gonna help myself. I'm incompetent. I apologize.
And Madam Clerk, there's also a Kyle McCoy on the docket in 23 CF 2699.
Hold on, wait. This is not that. Go ahead, Mr. McKinney.
Madam Clerk, with Mr. Kleins in 23 CF 2699 and 23 CF 2700. He indicated that he didn't know why that was on the docket for today.
Because we were here for Judicial conference last week, and then she says it was set for today.
Okay. I believe the intention was to set that for the January 13th court date.
Okay, it's continued until January 13th.
Yes, sir. Thank you, Judge.
Thank you.
The last inmate we had was Nathaniel Riggs with Mr. Still.
I did send, I pulled the email off of the clerk's site, just to email Mr. Still about
Yes, sir.
today.
Right.
That was not long ago, so.
Okay. Mr. Riggs, when you were here before, I'm trying to figure out exactly why you're here. The last time we were here,
The last time that we were here, Your Honor, we were going to continue the case.
and his,
I'm covering for ASA Sandler, and when he appeared at the last court date, I believe he represented to the court that he had not necessarily talked with Mr. Still about that.
That's
And so you
what I
wanted an
thought.
update.
Your Honor, I can answer. So on pre-trial conference, the attorney did not appear, so we set it for today. And then they filed a motion for continuance, and then an order of continuance was filed on the 15th, and it sets it for January.
okay, so I did grant the motion for continuance. Mr. Riggs, I got caught in the system. I hate that because I really wanted, have you talked to Mr. Stills in the last week?
Yes, sir. He contacted my mom.
Okay, so you feel comfortable with what he's doing?
Yes, sir. Yes, sir.
Okay, well, that was what I wanted, is I wanted some communication.
Oh, yeah, we communicate all the time. We
Excellent.
communicate through my mom.
Okay. Then the court will see you no later than January 13th.
Okay, yes, sir.
Thank you, sir. Thank you. Okay. Okay, Madam Clerk, you've got it. What are we doing now? Okay, Mr. Koch.
These are actually all of them.
All with Mr. Koch, okay?
All right. Judge, Dwight Parson, this was set, the alleged victim failed to show back in October 30th. We set it here. Speaking with Mr. Gomez, he wishes it to be continued to the 13th. I have no objection. Unfortunately, I don't know where my client is. I've had great contact with him. He was here on pretrial. He knows to be here.